I'm Dave Crouch, and this is the Chamber of Commerce Public Affairs Roundtable, and it's a lively morning here, and pardon my bumbling a little bit here, but we've got a good crowd and a lot going on in the audience this morning. So glad to have you with us, and hope that you will find this show very helpful. We've never done one quite like this before, but the amendments on the ballot November 4th are going to be a little bit they are a little bit confusing to me. Not that I would call anybody's draft of an amendment confusing, but we thought it was important to highlight these amendments and talk about the politics behind them, talk about the pros and cons. Hope you've got opinions on them. But I hope if you decide to speak up that you'll be respectful and brief. So we're going to allow some time on each amendment for the audience to ask questions or to make a short comment, and look forward to your input there. We've got with us this morning our regular Williamson County Legislative Delegation, Senator Jack Johnson, Representative Charles Sargent, Representative Jeremy Durham, and Representative Glen Casada. Glen, no slight meant, but Glen was cutting the time close, so we bumped him down to the end this morning. But
fair enough.
Seniority-wise, he would be right this side of Jeremy. And we've got a special guest this morning, and we'll talk more about this in just a minute, but the Chamber has decided to endorse a yes vote on Amendment 2. And the proponents of Amendment 2 have asked Judge Jeff Bivins, our Williamson County's own member of the Tennessee Supreme Court, to help explain this amendment to us this morning. Jeff, we're very glad to have you with us this morning.
I'm very honored to be here with you. Very glad to be here. Thank you.
And I called you Jeff, and
Please do.
I'm having trouble getting used to calling you Judge Bivins.
I tell people that one of the worst things about this job, or any job as a judge, you lose your first name, so I'm happy to go by Jeff today. Go
right. And you were appointed by the governor this past July.
Correct.
And you've, prior to that, you were on the appellate court, I believe?
That's correct. I was on the Court of Criminal Appeals beginning in August of 2011, and then prior to that, I was one of the circuit court judges for the 21st Judicial District, which includes Williamson County.
Right, great. And you are a Franklin resident.
I am a Franklin resident for many years, since 1986.
I know from seeing you at Centennial High School over the past few years that you've got kids somewhere near my kids' age. I got a late start, by the way, and I'm not near as young as Jeff is, but Judge Bivins. But you've got children. What age?
I have a 24-year-old and an 18-year-old. We just, this is the first year we've been away from Centennial for a while. We've had a very pleasant experience there and enjoyed the many years we spent there.
Great. Well, we certainly appreciate your service and appreciate you being with us this morning. We're going to start off with Amendment 1 this morning, and again, I'm not quite as smooth as I'd like to be, but we're just going to go ahead and admit it and move on. Amendment 1 says, nothing in this Constitution secures or protects a right to abortion or requires the funding of an abortion. The people retain the right through their elected state representatives and state senators to enact, amend, or repeal statutes regarding abortion, including, but not limited to, circumstances of pregnancy resulting from rape or incest, or when necessary to save the life of the mother. Gentlemen, in my research, I didn't pick up who sponsored this, but why is this amendment on the ballot, and what are we trying to accomplish with that?
Yes. There was a court case, Sundquist versus Planned Parenthood. In that court case, the state Supreme Court opined that, in essence, an abortion is such a sacred right that the legislature, the people's elected body, has no right or insight into this entity. And the legislature had and would like to put such things as inspections of clinics, just like you do the vet clinics, just like you do every other clinic or health facility. There needs to be inspection. But according to the Supreme Court, that cannot be so.
May I clarify?
Go ahead, Jeff.
That's the 2000 Supreme Court.
Yes. Yes, thank you. I was throwing no dispersions on the current Supreme Court. That's one example. Or parents. Most Tennesseans think that parents need to know when their minor child has this procedure. In our schools today, you cannot take an aspirin without parental consent. And so these are just a couple of no-nonsense things that need to be instituted on this procedure called abortion.
Gotcha. Any more color from the House, Jeremy?
Just want to be clear that there is a federal law of the land. There is Planned Parenthood versus Casey, which says you cannot create an undue burden on a woman who's trying to have this procedure done. Now, once you have that kind of language, you're going to have other cases that explain exactly what an undue burden is. And it's been held like 24-hour waiting period and some of the things that Glen has mentioned. Now, that makes it very confusing because the state constitution, we're trying to amend that to basically go further than what Planned Parenthood versus Casey allows right now. The reason for that is because if for some reason federal case law changed, the advocates of the amendment would want, let's say instead of a 24-hour waiting period being upheld, let's say they said we'll go all the way to a week. Then they would want the amendment process to just go ahead and be there. You wouldn't have to go ahead and institute another amendment. So again, there's a federal floor. You cannot create an undue burden on a woman who's wanting to do this. But this amendment, right, if it were passed tomorrow, it would be like 24-hour waiting period. It would have to do with taxpayer-funded abortions, third trimester, hospitalization requirements, basically inspections on your third trimester. Now, however, if Planned Parenthood versus Casey were, if that were altered by another federal case, then it could potentially go a little bit further. But I think people are getting confused because the rape and incest language is in the amendment. It's making people think that the state can go further than what Planned Parenthood versus Casey allows. But what that is called is a trigger provision. So if the federal case law changed, then that language would matter. I hope that made sense. I saw a couple people nodding. I think I lost everybody else after about 10 seconds.
I got in the weeds on that a little bit, but Charles, Jack, any further?
I think as the lawyer sitting next to me explained it fairly well, but this just gives us as legislators provisions that we can make it stronger. Like we said, a 24-hour waiting period, these facilities to be inspected. Should the doctor at a facility, Planned Parenthood facility, should they have privileges at a hospital because if something goes wrong, they should go with the patient to the hospital. Most of them do not have privileges at hospitals. So we're just trying to strengthen it to the point of being very reasonable on what we're doing.
Two quick points, Dave. Again, just to add a little bit more historical context, it was back in the mid to late 1990s when the Tennessee General Assembly passed three provisions regarding abortion. They were signed into law by then Governor Don Sundquist. And I'd like to point out that at that time, the Tennessee General Assembly was overwhelmingly democratically controlled. Overwhelmingly democratically controlled. Now, we had a Republican governor. So Democrats en masse supported such reasonable things as waiting period, informed consent, parental consent. Those laws were passed overwhelmingly by the General Assembly. The people's elected representatives signed into law by the governor. They were challenged by Planned Parenthood, and they made it to the Supreme Court. And in an act, the then Supreme Court, which does not resemble today's Supreme Court, in what I believe is a blatant act of judicial activism, ruled two of those measures unconstitutional. So you had 5 Supreme Court justices that overturned the will of the people of the state of Tennessee. And that's what led to this battle. And obviously, I think that the overwhelming majority of Tennesseans would support such common sense things as inspections and waiting period and so forth. And that's why this amendment is so critically important. And it's probably one of the things that I've been involved with in my time in the General Assembly that I feel more passionate about than anything. So I respectfully urge people to vote yes on one.
That, I think, explains it to me very well. Judge Bivins, have you got anything to add to that?
I think they've covered the subject quite well.
Great. Well, that's great. We are going to let the audience, if you've got a question or clarification or something that you'd like to add to that, feel free to step to the mic. We would be glad to hear
Dave,
your...
as they're coming forward, I'm sorry, I said two things and I only said one. And I forgot that the other one that I wanted to point out as we get ready to hear from folks in the audience.
Go ahead.
Tennessee, as a result of that Supreme Court decision, has among the most liberal laws regarding abortion in the entire nation. 1 out of 4 abortions that are performed in the state of Tennessee are performed by people coming from out of state. Tennessee has become an abortion destination because our laws are more liberal than the state of Massachusetts. Can you believe that? The state of Massachusetts has some of these restrictions in place, some of these very common sense restrictions. Tennessee is known for a lot of things. I don't think we want to be known as an abortion destination in the United States of America. Please vote yes on one.
Very good. Give us your name and address. And
My name is Vic Sand Creek. I live at 218 Gloucester in Franklin. And I listened to the gentleman, and I hear what they said about we need to put inspections back in. But there was a letter to the editor in the Tennessean last week. A reader said that she called the Board of Health, and the Board of Health told her that they inspected the bejesus out of these abortion clinics.
Right.
Okay? So either she's not telling the truth about talking to the Board of Health, or the Board of Health has their employees giving misinformation. What can we do about that?
There's a court case called Knowles versus Tennessee, which in essence says that that is an undue burden if you inspect the clinics. Now, Tennessee goes through it. Most, not all, but most of the facilities in the state that are left do allow it, but at the end of the day, they don't have to, and at the end of the day, if you fail inspection, we can't close you down.
Right. So what do we do about the Board of Health telling people this? I mean, is that true?
It's true in that this part, if the clinic allows, they can go in and inspect, and most do. But again, according to the Supreme Court decision, at the end of the day, if the Department of Health wanted to close them down, they can't.
Okay. Thank you.
thank you. Yes, sir.
Bill Qualia at 163 Cornerstone Circle. Gentlemen, thank you very much. That was very clear and concise. The only thing I would add to that is the fact that this judicial system, when they enacted this thing, it went further than Roe versus Wade, and that's all I had to say.
That's right.
Okay. One more spokesman on that subject.
Good morning. I'm Dan McCormick, 605 Countryside Court. I've been knocking on doors in support of Yes on One, as well as being out here at the polls. And oftentimes it's brought up that there's other ways to have addressed this. I'm talking about the opposition. They didn't have to do this to the state Supreme Court. Could you answer that and give an explanation of why it's absolutely essential that this be put back to a neutral position, our Tennessee State Supreme Court, so that these common sense regulations can be put in place?
Basically, what Planned Parenthood versus Sundquist said, they said that the law of the land clause in the state constitution, the Tennessee Constitution, goes further than the due process clause in the federal constitution. Now, personally, I know they were both derived from Chapter 29 of the Magna Carta, so they're explaining the exact same right, so it's impossible. However, that's what they said, and they're saying that in Tennessee, you have greater protections for these procedures than the federal case law requires. So if the federal law says we're going to make states allow women to do these procedures right here, Tennessee went further. So we're trying to go back to here. And even if the federal guidelines move, Tennessee would move with it. That's what Amendment 1 would do. Because right now, yes, we go further than the federal government allows us to. And most states, we are very much in the minority as far as how much protections we give to abortions.
Yes. And as a result of that, if Yes on One doesn't pass and it stays the way it is, can Planned Parenthood and the ACLU challenge other existing restrictions that are in place, such as the parental consent requirement or such as taxpayer funding and so forth?
My understanding is the parental notification of a minor has already been struck down. I don't think we don't have that unless I'm just totally wrong. I believe that's been struck
I think
down.
we have it, but there's a judicial bypass provision that makes it very
gotcha.
easy for them to get by.
I got you.
Okay.
That is why we have Justice Bivins.
You know, Dave, it's good to have attorneys around every now and then, just every now and then.
It's great
As long as
to,
they're not in the legislature, right?
great to have a judge with us this morning, and we're glad to have Judge Bivins on any topic that he chooses to weigh in on. In the interest of time, we're going to move on to one more quick one. Sir?
Good morning. My name is Dan Kramer. I'm actually living in Clarksville at 449 Winding Bluff Road. But as possibly having to represent the area, I wanted to make sure I understood the interests of the people who live here and the amendments, because people ask me a lot about them. I got a quick question. Mr. Representative Durham, you said that the intent is if Amendment 1 passes, that you would immediately be looking to write legislation that would go beyond the restrictions of Casey, so that then there would be a new standard in case federal restrictions were eased? Did I
I think
understand
that's
that
the opposite
correctly?
of what I said.
Okay.
I think I said that the
Could
federal
that-
guidelines require that we cannot go further than Casey.
Okay.
States cannot go further than the federal law allows them to go, because the U.S. Supreme Court has found this to be a right of privacy
Right.
issue, a fundamental right, so we certainly cannot go further than they allow us to go.
And as I understand it, the Supreme Court's, the Tennessee Supreme Court's ruling in saying that by women's right to privacy guaranteed through the Tennessee Constitution is what allowed the overturning of the two cases that they were in Sundquist versus Planned
That's right.
Parenthood. So my question is, if Tennessee is known as, and it's, in all these great polls, as one of the freest states where we, in theory, enjoy the most rights, how do we further our cause by writing a constitutional amendment that restricts rights?
Well, there are,
Protect life.
right, there's.
Because your most fundamental right is the right to life.
Yeah, if you take
I
away
believe there's a
life,
compelling state
But-
interest in that of an unborn child. I mean,
Okay, but
whether or not you
we
value
are,
that.
but we are talking about regulating a currently legal procedure,
that takes life,
but it is a legal procedure.
that takes life.
Well, we make laws to make things that are legal not legal and not legal legal.
All right. Well,
I think we now understand the
and
other
I
side.
don't- yeah, and this is the last follow-up question here. Do you imagine that if it passes, that it will be immediately challenged with further court cases? And if so, who picks up the tab for those?
No, I mean, if all we're doing is going in line with the federal case law, then what's the challenge?
Okay.
What grounds would you challenge?
Well, if you immediately can pass legislation that bans abortions, even in cases of the health of the mother.
Well, that's what Texas did, and they got struck down anyway. You don't need to
Okay.
pass Amendment 1 to pass an unconstitutional law.
And it doesn't ban abortions.
You can do that now.
Well, it doesn't really say.
If we want to
anything.
pass an unconstitutional law, we can do it now.
Yeah.
It doesn't have anything to do with
We
Amendment
must
1.
move on. In the
All right, I
interest of
appreciate the time. Thank you.
And Dan, I
Appreciate your-
think for full disclosure,
Yeah.
you're a candidate for United States Congress?
I am, but I didn't.
Okay,
really
and
want to
you're
plug-
opposed to Amendment 1?
As a person voting in Tennessee, I oppose Amendment 1 because it is an intrusion of states into
Okay, no, that's
individual
fine. I
rights.
just want to
Yes.
make sure as a candidate,
Absolutely,
you
no
need to
problem.
declare your position.
Well, I didn't see any Democrats up here. So. Thank you, I appreciate that.
We're always interested to learn the pros and cons, but I think we got there on this one, and I appreciate the discussion. I think it's helpful to have everybody step in and make sure we air out the pros and cons. Moving to Amendment 2, we, as a chamber, the Williamson Chamber decided to endorse this measure and passed a resolution that I would like to read so that you clearly understand the Chamber's position on this measure. We think it's a good idea. And our resolution reads like this: a thriving economy is built on a stable and secure legal foundation. In Tennessee, we're privileged to have a government that supports business, including a judicial system that ensures fair, consistent, and predictable outcomes for all who seek justice. Williamson, Inc. believes that Amendment 2 will further enhance our judiciary and promote the selection of the most capable appellate judges for our courts. Amendment 2 ensures that both the executive and legislative branches have authority over the appointment of judges and affords the people a direct say on their retention. Williamson, Inc. supports Amendment 2 and urges its members and all voters to vote for this important initiative. So just to be clear, wanted you to know the Chamber's official position on this amendment. We have not taken a position on the other amendments, but as a Chamber, we thought this one, from a business perspective, is important and wanted to clearly support that. Judge Bivins, you have spoken in favor of this amendment, I think, in a couple of venues, and could you tell us more about why most of the governors, former governors, many other chambers in this state have decided to endorse this?
I'd be happy to, Dave. Thank you for the opportunity to do that. And yes, you are absolutely correct. This has been strongly endorsed by Governor Haslam, by Governor Bredesen, by, I think, all the chambers that have addressed it across the state, by numerous other business organizations. The Farm Bureau is a big supporter. It has broad range support. But let me just touch upon why I would suggest to you and encourage you to vote for Amendment 2 here this morning. First of all, let's put it in context what we're talking about. We're talking about the 29 appellate judges in the state of Tennessee. We're not talking about trial judges. This in no way impacts the selection or election of trial judges. It deals solely with the 29 appellate judges. That being 12 members of the Court of Appeals, which hears appeals in civil cases, 12 members of the Court of Criminal Appeals, which hears appeals in criminal cases, and the 5 members of the Tennessee Supreme Court. That's all 29 of those are subject to statewide elections. And I dare say, if I would ask you to raise your hand, how many could identify even 5 members of the appellate courts of those 29 today? That many of you would be hard-pressed to do so. It's hard for me as a member of that 29 to remember all 29. So it's a very difficult process to become educated if we're to have simple open elections and open contested elections with that. The process which in essence is dealt with Amendment 2 has been in place, at least for the intermediate appellate judges, since the 1970s. Basically what that process is that there is an initial commission that screens the applicants for that position. Then that commission interviews each one of those, reviews a lengthy application, conducts public interviews, and then submits 3 names to the governor. The governor then selects one of those from that list, and then that person is subject to a retention election, which at the next general election. There has been much debate about whether a retention election truly is an election as currently written under the Tennessee Constitution. I would suggest to you reasonable minds can differ on that. There have been 3 special Supreme Courts, and I emphasize special because that means that it have been members that have been specially appointed that have no interest in that have said that it is a constitutional way to do things. And just for a moment, let me, as an aside, point out what those courts have said is not to dictate how the election takes place. What the courts have done is said these members of the legislature have the authority to decide what type of an election takes place. They have decided that the proper type of an election for members of the General Assembly is a partisan contested race. On the other hand, they've decided that the best type of an election for a judicial race, for appellate positions, is a retention election. And that is because we as a judiciary cannot discuss issues. We cannot debate issues. We cannot take a position. You know, we're talking about restrictions that in dealing with Amendment 1. I can't sit here today and tell you how I would vote on those if they came before me as a justice. And so what you have are hands tied and not knowing what those positions would be. Magnify that by 29 times. You're looking at 29 people you're trying to vote on, and you have no idea what their position is at that point in time. At least if you go through the process that we're talking about now, you have a very lengthy application process that is done. Any applicant has to fill out a multiple page in all of your history, everything you've been involved in your past professional life, a lot of your personal life. You have to sign waivers as a lawyer to allow the Board of Professional Responsibility and the Board of Judiciary to report any actions against you during the course of that time. If you're selected as one of the three, you have to fill out a TBI disclosure form. It's a level 2 security clearance in the state. They'll go and talk to your neighbors and ask you about you. I mean, it is a very lengthy. If you filed a bankruptcy, we'll know about it. Okay, so all that's in place now. Amendment 2 will allow that to continue to be in place and add one more aspect of it. In addition to the prospect of having the screening committee that would now be, the governor would have discretion under the amendment, but this governor at least, and we hope governors in the future, would set up a screening committee by executive order. And that screening committee would function just like the Judicial Nominating Commission did that the legislature set up. It would interview those candidates, submit those 3 names to the governor. Those 3 candidates then would fill out the security clearance form. All that information is gathered before that appointment's made. In addition, those applications are open to everybody. They are online, folks. If you want to know what an applicant has said in their application, all you got to do is go online and find out about them. What do you know if you don't? If you have a direct election, there is no way to know that. So I would suggest to you that the combination of the people having a right to say who they picked in their governor, who they pick for their legislature, that gives the legislature a veto through this amendment, and by way of the direct retention election, is the reasons to vote for Amendment 2.
Okay, so to summarize, the Amendment 2 will institutionalize the current system plus add the layer of legislative approval
That's
to the
correct.
existing system.
Must affirmatively reject in 60 days.
Right.
That's the only difference.
It actually operates at more of a veto power than it does a confirmation power.
Right.
You must reject. Both houses reject within 60 days. And if it's a recess, then it starts when we go back in session.
Right. Senator Johnson, give us a political background on this.
Sure. Well, it's actually something that I've been intimately involved with since about my first day in the General Assembly, and Justice Bivins did a great job, but I'll add a little bit of historical context. As he said, in the 1970s, the General Assembly, up to that point, we had elections. But I want to point out that, if I'm not mistaken, that we had elections, but the nominees for those elections were selected by the state party.
That's exactly right.
It was not an open primary.
This is an August state election. It's not a November election.
Exactly. So there were not popular elections in the primary. The nominees, Democrat or Republican, were selected by the state executive committees of the respective parties. So that's an important distinction. The General Assembly, when Winfield Dunn was elected governor, because again it was controlled by Democrats, they didn't want Winfield Dunn selecting Supreme Court justices. So the General Assembly came in and removed the 5 Supreme Court justices from this merit selection type process and returned them to popular elections. And that remained in place until 1994. In which case what the modified Missouri plan, which is what Tennessee adopted, which is basically a merit selection type of program, was put in place for them as well. But the history of this all stems from those words in the Tennessee Constitution that these justices shall be elected by qualified voters of the state. And although 3 special Supreme Courts have ruled that what we're doing now satisfies that constitutional language, there are many in the General Assembly that just doesn't set right with them. And if anything, we all take very serious, as we all do, all of us who are appointed or elected officials up here, the oath we take to uphold our Constitution. And that's why there has been this simmering debate over the last 20, 30 years, if you will, going on for close to 40 years, I suppose, with regards to how we do this. And this amendment will once and for all satisfy that consternation, if you will, or resolve that consternation that exists. And I do support Amendment 2. And I submit this, and Justice Bivins touched on it, but I'd like to reiterate it. What is the best way for us to select our Supreme Court justices? And another quick aside, that qualified voters of the state shall be elected by qualified voters of the state only applies to the 5 Supreme Court justices. There is no such constitutional language for the remaining 24 appellate court judges. And so, even if you disagree with that language with regards to Supreme Court justices, that language does not apply to the intermediate appellate court. So that process is constitutional. But this amendment, as drafted, would affirmatively constitutionalize, if that's a word, the process that we're using across the board. So I ask you this question. We can get bogged down in a lot of the historical context, and some of the folks opposed to Amendment 2 really stress that constitutional language. And I share some of their concerns about it. But what is the best way to select these 5 Supreme Court justices? Do you want to have people running statewide campaigns? As someone who has participated in a number of campaigns as a candidate and as a volunteer, I can tell you the number one thing that determines a statewide election, M-O-N-E-Y, money. Money decides statewide elections, whether you like it or not. And so if we're going to elect 5 Supreme Court justices statewide, the number one driving factor will be money, which buys name ID, and people elect names that they recognize. And I just submit to you, do you want to have that happen when these candidates can't tell you what they stand for, they can't tell you what their position is on any particular issue? You're going to be, as Tennesseans, we'll be electing people whose names we recognize most. And I got news for you. There will be tens of millions of dollars poured into this state from places all over the country to try to influence these elections. Now, that happens in our races, it happens in United States Senate races and governor's races and so forth. But there is a vested interest on the part of trial lawyers all over this nation to have influence in terms of our Supreme Court in the state of Tennessee. And I would just submit to you that's not the best way. The founders of the United States Constitution put a selection process in place for federal judges, and it's worked pretty well for the 225 some odd years that our nation has existed, and that's what we'll be putting into place at the state level for our appellate judges and Supreme Court justices. So for all those reasons, I support Amendment 2. I share in some of the discomfort with regards to, are we doing a process that's constitutional now? This amendment will make it constitutional, and I submit to you it's the best way to select our justices.
Representatives, how about some color from the House?
I'm in support of Amendment Number 2. Also, I'm voting yes on Amendment Number 1. I want to make that clear. I think
That's
Jack,
something that I've been meaning to interject here, but all these amendments had to get a majority of both houses.
And
Correct.
then 2/3.
No, super.
what happens,
Okay.
it has to be read in one General Assembly. It has to have the majority. In the second General Assembly, the whole, 2 years later,
Right.
then it has to be voted on in the second General Assembly and get a 2/3 vote, a supermajority vote. So these have gone through 2 different General Assemblies, not 2 years. I'm talking, it actually takes 4 years. They've gone through 2 General Assemblies. First time a majority, second time what we call supermajority, a 2/3 vote on all these amendments. On Amendment Number 2, the other thing people say that you cannot get rid of one of these judges. As you remember, they can give me the year that Penny White was on there.
1996.
1996. They voted not to retain Penny White, and she was replaced as a judge. So it's not an election where you're going in and voting for a person, but she was replaced and off the Supreme Court. So we can get rid of these judges, even though they say you're not up for election, but you are on a retention vote. She lost that retention vote, so she was replaced. So we do have the election process when we look at that. I think Jack did an excellent job, and Judge Bivins did an excellent job. So not much more I can add to that.
There's nothing else to say.
Yeah, I mean, they both did it well, and good explanation. Actually convinced me. I at one time was kind of leaning towards no, and after hearing these guys speak earlier, I said, okay, we'll try it.
If I can, just make 2 real quick points as well, David.
You gained 1 vote.
That's right. Jack's talking about the outside money and the cost. If you look at those states in which they have direct partisan elections for Supreme Court justices, it's costing $6, $8, $10 million per seat for an election. And then the last thing is to emphasize, as Jack said, this puts to bed once and for all the issue of retention elections. And it resolves it, and I think it's going to allow the judiciary and the legislature to move on to bigger and better issues together.
Well, just to kind of add some color to the what could happen if this doesn't pass, as I was preparing for this show, I ran across the story about the Alabama, I believe it was, Supreme Court judge that attracted $3 million from a coal company executive that had an issue before the Supreme Court, and that judge ended up being the deciding vote in a case in favor of that company, which I think it was later reversed at a higher court level. But it's just an ugly way to appoint justices.
That actually was, and that article did say Alabama. It actually happened in West Virginia, but it involved the justice there, and went all the way to the U.S. Supreme Court, and the U.S. Supreme Court ruled that justice, even though there was no direct evidence that he was being paid off or anything, there was too much potential bias, and so they had to reverse the entire judgment.
Right. Well, I think anybody that's familiar with the way the governor and the selection commission has handled these things should heartily endorse this amendment, and we appreciate your color on this. Moving on to Amendment 3, and I didn't read Amendment 2. I think from all the discussion we certainly understand that. I'm going to go ahead and read Amendment 3 and then ask Representative Casada to tell us a little bit more of the reason behind this amendment. Notwithstanding the authority to tax privileges or any other authority set forth in this Constitution, the legislature shall not levy, authorize, or otherwise permit any state or local tax upon payroll or earned personal income, or any state or local measure or local tax measured by payroll or earned personal income. However, nothing contained herein shall be construed as prohibiting any tax in effect on January 1st, 2011, or adjustment of the rate of such tax. Glenn, tell us what this does.
The history on that is that most attorneys and most logical people, when they read the Tennessee Constitution, in their opinion, already says there should be no tax on earned income. The problem and the reason for this constitutional amendment was that we had two attorney generals to opine that, yes, there is room to tax earned income in the state. So obviously the Constitution wasn't written clear enough for the attorney general, and this is the reason why we're putting this into, to make it even more clear that you are not to tax income. The reason why we think this is important is because I and many economists feel like that a consumption-based tax is much more fair on the consumer. It's much more resilient in down times. It bounces back much quicker in up times, and it's a better way to raise revenue than taxing income, which is a great disincentive. And so this is a way to make sure Tennessee stays an economy based on consumption, not taxing of income. And I think it's sound, and I would urge everyone to vote for Amendment 3.
Gentlemen?
I think Glenn explained it well, and I suggest everyone vote for Amendment number 3. Do not confuse this. Will not do away with the Halls tax, because the Halls tax is, a lot of people, it is an income tax, but that's on unearned income. So it will not do away with the Halls tax. We're trying to get rid of the Halls tax. A lot of people think this will do away with it. This will not do away with it, because the way this reads is strictly on earned income, not unearned income of interest and dividends.
Right. Did the Senate handle it any differently?
No, we didn't. Senator Brian Kelsey carried this amendment, and it passed overwhelmingly. I think it's important to point out that we're having this conversation about Amendment 3. There is not a chance in heck that that this General Assembly or this governor would pass a state income tax. That's very, very important. There is no discussion in the Tennessee General Assembly now, or will there be in the foreseeable future, of a state income tax. So people are saying, why is this so important? Well, this great event is hosted by the Chamber. And I think that the folks involved with the Chamber, who are busy recruiting companies and recruiting businesses to come to the state of Tennessee, as Glen said, they need that certainty. When you're talking about a multi-billion, sometimes dollar corporation that is contemplating leaving California, where they have a 13% state income tax, 13% on top of what you pay federally. Imagine that. And so naturally, a lot of companies are leaving California and leaving other high tax states, and they're looking for a place to go. And they're looking at states like Tennessee, Texas, and Florida that have a much more favorable tax structure. Well, these companies, when they look at moving a corporate headquarters or moving a distribution facility, they're looking at an investment that spans decades. I mean, that is a very long-term investment. Having this language in our Constitution will assure them that even if the composition of the General Assembly were to change in 10 years, 15 years, or 20 years, which could happen, it could happen. I hope it doesn't. I hope we don't go back to Democratic control, but that could happen at some point, and then they could end up proposing another state income tax. Putting this in the Constitution will give them that additional degree of certainty that we will not have a state income tax on earned income in the state of Tennessee.
That's good. That's great. Now, theoretically, not having a state income tax should ensure that the Tennessee Titans are able to recruit the absolute best athletes in the country. Is that not right?
Oh, that's painful.
They need something.
Well, let's hope the future is better than the present.
You know, Dave, and if as we leave the practical to the theoretical, the reason that states like Tennessee are doing so well is because our tax structure is low. Businesses come to Tennessee from other parts of the country, which in turn, it built upon this concept of, which in turn gives more economic freedom and more economic prosperity for the citizens, which in turn allows for more independence of government and government dependence, which in turn makes for a stronger community, a stronger state, and stronger families. And so we think this is the heart, this no income tax, of a prosperous and successful and independent state and citizen compared to the rest of the nation.
Right.
It's one of the best things we have to attract businesses. I'm glad that we're putting it in the Constitution.
Gentlemen, we appreciate your leadership on these, and in particular, Glenn, your leadership through the House on this. Amendment 4 is one that I had a little bit of trouble getting my arms around, and I'm not going to read it all because it's long. I'm sorry. Absolutely. We didn't allow audience participation.
I know you've got a big agenda.
But
I'm Brian Eccles from Brentwood. I'd just like to ask what impact, if any, this would have on franchise and excise tax levied on businesses.
It will have no direct effect on that. Now, there is some discussion how it has none on that. There's some discussion on the deduction that companies will have, but I've been my impression that it would have no effect on that, on the franchise excise.
okay. Any other questions? Comments? Very good. Amendment 4 is regarding lotteries in Tennessee and the types that are allowed, the types that are not allowed. And I would like someone to give us a little bit of history on the bingo business and how our laws got the way they are and what this actually does with regard to the history of bingo in Tennessee. Who would like to?
Charles, were you there when that happened?
I'll attempt. When we passed the lottery bill, as far as that's concerned, to have Powerball, to have your scratch offs and everything else, that passed overwhelmingly. As far as that's concerned, all this will do, I'm going to tell you exactly what this will do. We did it, and we allowed 401c3s, 501c3s to hold a raffle. On that, we left out 501c4s, 19, okay, which are basically all our service organizations, the VFWs, all those. They were not allowed to have a raffle. All this is doing is allowing all our armed forces, all their different organizations to hold a raffle. One time a year, just like St. Jude's raffles off a house, it'll allow these people to do a raffle one time a year.
And the history, Dave, it goes back to, what, the 80s, 70s, 80s?
80s, yeah, 80s.
People remember the Rocky Top scandal, okay? And the Rocky Top scandal, basically, there was a different system in place there, and you could have bingo, and a lot of people were playing bingo, and the licenses to be able to do bingo were very, very valuable. And there was some corruption involved. There were some members of the General Assembly that were prosecuted and convicted as a result of accepting bribes to get these bingo licenses. And so that's kind of what led us to where we are. Now we allow these charitable organizations to do a raffle once a year. It's passed in an omnibus bill, an ominous, could be that too, in an omnibus bill where they're all listed, and again, it could be St. Jude, it could be, all these various charitable organizations, and they can do one a year, and they can raffle something off and raise money for the organizations. But it only listed 501c3s, and again, veterans organizations are recognized by a different section of the IRS code. They're under 501c19. So this will simply allow our veterans organizations to be treated the same as 501c3s.
Okay. Any additional?
Amen.
Bingo. Bingo. So, any chance of bingo coming back? I mean,
No.
Just wanted to get that on the record and understand that clearly. So we've got 4 ballots. They've all overwhelmingly passed the Senate and the House, the resolutions. And I think the consensus is fairly clear among our delegation here that you all would support voting yes on all 4 amendments. Is that correct?
Yes.
Okay. And again, the chamber would like everyone and their friends and family to vote for Amendment 2. And we just want you to understand that's clearly a business issue and would be to the benefit of our business community. We have a little extra time, but we've got some special guests with us this morning from the Nashville Chamber, and I think they've got an award that they would like to award to some of our panel up here. And if you would come forward to the microphone and tell us who we're going to honor this morning.
Is this one to go? Thank you very much, David. I'm Bradley Jackson. I'm actually with the Tennessee Chamber of Commerce and Industry. Let me tell you all a little bit about why we're here today. First of all, let me talk a little bit about the Williamson County Chamber and the work that you all do with Matt. We interact with all 95 chambers really across our state, and the Williamson County Chamber here does an excellent job of engaging with our elected officials and staying up to date on the hottest issues and having the involvement, and that is crucial for the business community in Tennessee. The state chamber, we've been around since 1912, and our mission is very simple. We work in the legislature. We want Tennessee to be the best state in the nation for business, and we feel like we have an excellent track record, and it's largely due to the officials that we have and the engagement that we have. The state chamber works on a number of kind of deep issues, maybe taxes, unemployment, workers' comp, the things that aren't necessarily fun, but they are really the nuts and bolts what makes Tennessee a really good state for business. So at the conclusion of each session, the state chamber, we take a deep dive and look at not only votes, but how members have participated with the legislation they have sponsored, the votes that we've taken on, and we have a key vote card. And Williamson County had a very good track record with the legislators here. We look back, and I think you all are probably one of the only counties that have 3 members here today who the Chamber Board of Directors looked at their record and decided that they deserve special recognition. Now, the one we left off is excellent as well, and I foresee in the future that we'll be coming back and giving it to everyone.
Gotta love the Medicaid bill.
But we're excited to take an opportunity. Like I said, it's a very limited number of folks that we give this to across the state. So what we're talking about here today is the Tennessee Chamber, the Champion of Commerce Award. It's an elite award. It's given to a very few. I think we estimate it's less than 5. It's about 14. So percentage-wise, it's a pretty low number out of 132 members. But we do these folks up here, every one of them, they do an amazing job for you all. You all have a great legislative delegation. They're interactive, and they're also in a number of important leadership positions, which is good for Williamson County as well. So with that said, I won't hold everybody up. We will maybe try to grab some pictures afterwards, and just want to thank you all for your work and everything that you do for us.
If you will, show the TV audience that,
Sure.
and the cameras up here.
And maybe tell us who's getting it.
And yeah.
Well, it is Senator Jack Johnson, Representative Charles Sargent, and Representative Glen Casada who were receiving the awards today. And in the future, Representative Durham, we're sure of it, as he had outstanding voting record. So.
And if we have time, we can present now, or we can wait.
Go ahead. We do have time, so.
Okay. All right.
Gentlemen, if you want to step up and.
The Common Core and the Medicaid Expansion Group wants to honor you. Get up there.
Sorry, Jeremy. We'll get more pictures after the
That's right.
after the
I'm having
meeting.
fun with this picture. Oh, I know. I don't want anybody to think I want the spectator.
Which one are we looking at first?
That's what I told Glen when they lost it. I was like, oh, there's your Common Core thing. Those are two big Common Core, right?
Let me go ahead and thank all of our audience for being here. We are going to conclude the television show at this time, and thank you all for your participation, and hope that our meeting this morning has provided clarification to you on how to vote on these issues. We look forward to reconvening the Public Affairs Roundtable in January of 2015. This will be our last show for 2014. And I want to particularly thank Newt Danley and his crew from Channel 3 for making this possible. We certainly have a great venue here with full TV studio facilities, and makes it so much easier for us to do hopefully a professional job in explaining the issues that come before us each year. Thank you very much. Look forward to seeing you again next year. Thank you.